Hello, Bruins, and welcome to the UCLA Alumni Association's Career Conversations series. My name is Katie Russo, and I serve as Director of Alumni Career Engagement at UCLA. First, thank you for joining us during this challenging time. The UCLA Alumni Association is working hard during this time to support you with resources and content. Our session today is Issues Regarding COVID-19 and the Workplace. It's my privilege to have UCLA School of Law alumna and employment attorney Angela Reddock-Wright as our featured speaker today. Angela is the founding and managing partner at Reddock Law Group, a boutique minority and woman-owned dispute resolution and investigations law firm based in downtown Los Angeles. A practicing attorney for nearly 25 years and named a Southern California super lawyer by her peers each year for the last 10 years, Angela's mission is to help employers and employees create great and healthy workplaces. In our conversation, Angela will share her employment law and human resources expertise to discuss COVID-19 considerations and implications in the workplace for individuals, business owners, independent contractors, and more. Before we get started, I want to address a few housekeeping items for today's session together. First, we'll have about 15 to 20 minutes of content from Angela, and then we'll leave plenty of time to answer questions you all may have. Many of you submitted questions when you registered, so we'll start with popular questions from there, but please utilize the Q&A feature, not the chat box, to ask your questions, and we will get to as many as we can, time permitting. Second, in a follow-up email, once our webinar ends, our team will share a webinar feedback survey as well as links to any resources referenced in the webinar today. Lastly, this webinar will be recorded, so you will have access to this after we're done today, especially for those who may have to leave early. Now, we will go ahead and get started, and I will turn it over to Angela to introduce herself and take it away.
Thank you, Katie. Can you guys hear me okay? Everything's good? Okay.
Yes.
I'm going to go ahead and share the screen just so we have that up and ready to go. Is my screen sharing?
Yes, you're good.
Okay, great. Let me put it in slideshow mode here. Okay, well, good afternoon, Bruins and friends of Bruins. It's so great to see you all in virtual land there. Again, my name is Angela Reddock-Wright, and I'm honored to have this opportunity to present to fellow Bruins today. Katie, you did a great job introducing me, so all I'll add is just that I'm UCLA Law Class of 1995 and very proud to be a Bruin. And what I do in my everyday work life, I've been practicing employment and labor law for about 25 years, and I was a litigator for 15 years, representing clients in wrongful termination, harassment, discrimination, the full gamut of employment law claims. And then in 2011, I opened my own firm to focus exclusively on doing what we call dispute resolution work. And that is working as a mediator, an arbitrator, and I also do workplace investigations. Each of those roles are neutral, meaning that I'm called in to help solve problems as a third party neutral and to bring a independent perspective to situations. And in addition to doing that, I love training and I love just educating employers and employees on issues in the workplace. And so this last 6 or 7 weeks or so that we have been in the COVID-19 pandemic mode and all have been social distancing and working remotely and working from home, I've done a lot of work and education around what this means for employers and employees and what we should know about it. So that's what today's focus is. And I know many of you probably have already attended numerous trainings, numerous webinars, and have looked at other resources to understand exactly what this means for you, your business, for you as an employee. So much of what I share, I'm sure you will know on some level, so that's why we're only doing 15 to 20 minutes or so on the actual presentation, but we want to leave as much time as possible for your questions because really that's where we are now, where people, they understand generally what's going on, but they want to know how it impacts their individual situation or their individual work environment. So with that, we'll go ahead and get started. And what I want to do is just review the basics, just so we're all working from the same basic set of understanding, and then we can go from there into the individual and specialized questions. And the disclaimer on my cover page is this is not legal advice. So I do want to emphasize that although I am a lawyer and I'll be sharing information that has legal implications, I'm not formally providing legal advice today. And encourage those of you who really need specific legal advice to reach out to an experienced employment attorney, either that represents employees or represents employers, depending on your situation. Okay, so we'll get started. So we have been in this pandemic now. I personally stopped counting. I don't even know what day of the week it is, how many weeks we're into this, but it was around March 26th, 27th or so when I think we all were out feverishly buying groceries, you know, and doing things that we needed to do to make sure that our households were prepared for this. And it was right around the same time that Congress initiated this act and began with passing legislation to try supporting all of us through this. And the first piece of legislation is called the Families First Coronavirus Response Act, also known as the Fcra, which I'll be referring to throughout the presentation. And then the other act, which most of us are probably most familiar with, is called the Coronavirus Aid, Relief, and Economic Security Act, also known as the CARES Act. And the word is befitting because I think it's intended at its core, although many of us have not realized the benefits of it as yet or having lots of frustration around it. I think that the goal of it is to show that our government cares about Americans and American businesses and are trying to help us navigate this situation. And that act, the CARES Act, has two phases to it. Phase one, which we'll talk about, which included unemployment benefits and the payroll protection program for businesses and other benefits. And then phase two, which was just passed last week, which expands the Paycheck Protection Program and also provides added benefits to hospitals and other first responder type employers. So the Family First Coronavirus Response Act, also known as FFCRA. Let me break down just a little bit. It was originally passed on March 18, 2020. So just about a month and 10 days ago. It feels like it's a year ago that we've been in the middle of this. And this act applies to private employers with 500 or fewer employees. To just move my screen here, 500 or fewer employees, and also, but some employers that have 50 or less employees may be able to seek some limited exemptions. So this act is intended for small employers, and employers that are even smaller, 50 or less, may be able to have some exemptions and some relief from having to comply with this particular act. What are the requirements for FFCRA? Employers that have 500 or fewer employees must provide employees that are impacted by COVID-19, and we'll break that down. What exactly does it mean to be impacted? These employers must provide employees with emergency paid sick leave up to 80 hours or the equivalent of 2 weeks or 12 weeks of paid family leave. And you see there that I have the word paid underlined, and that's because traditionally when employees need to take leave for their own medical condition or health condition or the health condition of a family member, an immediate family member in particular, that's usually unpaid leave. But what this act does is it provides paid leave specifically related to COVID-19 and by COVID-19. Who are the eligible employees? Eligible employees under FFCRA includes employees who are required to be quarantined or to isolate based on a federal government state or local order. the FFCRA, who is eligible for it. So employees who are required to be quarantined by our federal and our state and local orders. So here in Los Angeles and in California, we're definitely under order to quarantine if we're not working in an essential business. Employees who have been advised by a healthcare provider to self-quarantine. So if you've gone to your doctor and your doctor says, because of pre-existing health conditions, we believe you should quarantine, or because you may be more susceptible than others. For example, individuals that have diabetes or maybe experiencing some type of cancer or other medical illness that has their system compromised, your doctor may have ordered you to go into self-quarantine. Or, of course, individuals who actually have contracted COVID-19. I hope that's no one on this line, or may have symptoms of it, or as we're now learning that, some of us may have contracted it, but we have been asymptomatic. And so perhaps we've since learned that, and we are entering into quarantine based on the advice of our healthcare provider, or just based on our own decision to self-quarantine. Employees, so that relates to the third bullet point of an employee who is experiencing coronavirus symptoms and is seeking a medical diagnosis. This also applies to individuals. So the first three bullet points applies to individuals who have their own medical condition or isolation order as it relates to themselves, to the person individually. The next three sets of bullet points focus on an employee who may need to take paid leave because they are caring for another individual subject to quarantine or isolation. Now, under our normal leave laws, our unpaid leave laws, if we are taking time off to care for another individual, it usually has to be an immediate family member, such as a spouse, a child, or parent. The FFCRA is written broadly to say that if you're caring for another individual. So those of us who are practicing in this area, we are trying to seek guidance from the government as to, does that apply broadly? If you're taking care of your next door neighbor or your friend, are you still able to take paid leave under FFCRA? It also applies to individuals who are caring for a dependent that's under the age of 18, whose school or child care or daycare has been closed due to COVID-19. I know that applies to so many people. The schools are closed down, and it looks like in Los Angeles at least, and I know we have callers from all over the place, that the schools will be shut down at least through July. So parents are off, caregivers are off, guardians are off now, making sure that they're home with their children. So employers have to give consideration to that situation and possibly allow for emergency paid leave. And then individuals who are experiencing another substantially similar condition as specified by the Secretary of Health and Human Services. And what's missing there, it looks like I cut it off mistakenly, is if you go to the Federal Secretary of Health and Human Services website, it lists other conditions that may qualify individuals for emergency paid family leave. Okay, what benefits are allowed or paid under the FFCRA? So employers with 500 or fewer employees, and granted there may be some special exemptions if you have less than 50 employees, but if you are an employer that falls within this requirement and you have employees that fit within any of those 6 categories that I just described, you as the employer or the business are required to provide up to 80 hours of paid sick leave, which generally is equivalent to 2 weeks of pay. And that time is prorated for part-time employees. And you have to provide them paid time off. For full-time employees, it's either their minimum wage or their rate of pay, which is greater. So the minimum wage right now in Los Angeles is $12 and some change. So if you're paying them that amount, which you at a minimum you should be, or let's say you're paying your employee is $15 an hour. You would have to pay them the greater of the minimum wage or the actual full regular rate. So you would, if it's a $12 an hour person, I mean a $15 an hour person, you have to pay them $15 an hour. And that is capped at $511 per day based on an 8-hour workday and $5,100 total. That's if the employee is taking time off for their own health issue. If the employee is taking time off for another person's health issues to take care of someone else, whether it be an immediate family member or that someone else that we're seeking clarification on, the employer is required to pay up to 2/3 of that employee's regular rate of pay or the minimum wage, again, whichever is greater. And in this instance, it's cut a little bit less than half. It's about, the max is $200 per day or up to $2,000 a day total. One of the big questions that have come up as I have been talking about COVID-19 and work is whether employers can require employees to use their accrued vacation time or paid time off or other sick leave before they use this emergency paid leave. And the answer is no. And this is interesting because under normal legal analysis, when we look at normal unpaid leaves that are provided under laws like the Family Medical Leave Act or other state leave laws in California in particular, in most instances, employers can first require employees to take any accrued vacation or sick time off or paid time off, depending on what your company's policies are, before they are eligible for, or to have them take that concurrent with any unpaid leave that they get. So for example, under normal analysis, our Family Medical Leave Act, which is 12 weeks, up to 12 weeks of unpaid leave for an employee's own serious health condition or the serious health condition of an immediate family member. In that situation, if an employee takes the full 12 weeks of unpaid leave, let's say that employee has 2 weeks of vacation time on the books and 1 week of sick time. Those 3 weeks total would need to run concurrent with the unpaid family medical leave of unpaid 12 weeks of leave. So in this instance, under the emergency paid leave, there is no requirement that employees first use their accrued vacation or paid time off or other sick leave. So that's been an interesting aspect of these emergency laws that are being passed. Okay. Additionally, in addition to the paid leave for your own health condition or for the health condition of another person, FFCRA also provides an extension to family medical leave. And that's referencing what I just talked about, Family Medical Leave Act, which is traditionally 12 weeks of unpaid leave. So this provides an extension of that by saying that employers that have 500 or fewer employees, with the possible, caveat that employees of 50 employees or less, must provide 12 weeks of paid leave for employees who need to take time off to basically be with their children because their children, the schools are closed or the daycare is closed. So that requires 12 weeks of paid leave. Well, it's actually 10 weeks because the first 2 weeks are covered by the emergency paid leave, which I just spoke about. And then the other 10 weeks are covered by this expanded family medical leave expansion. In order to qualify for this, employees have to have been employed for at least 30 calendar days prior to their requesting the leave. So if this all started, say, the 3rd week in March, and an employee was employed by a month before that in February, then that employee could be eligible for this type of leave. Or if you bring on an employee right now and they say, hey, I want to take family medical leave, then there's no responsibility of the employer to provide that until that employee has been employed at least 30 days. Okay, so I know that there's a lot there, and Katie, I imagine we have a number of questions, but let me just finish FFFCRA portion. What benefits are required for the 12 weeks of unpaid leave? So as I indicated, the first 2 weeks will be covered by the emergency paid leave, which was the first thing we talked about. And there's no duty to use accrued paid sick leave, vacation, or PTO. And the compensation for this, for the 10 weeks, the 12 weeks, or the 10 weeks of unpaid leave, of paid leave, is up to 2/3 of the employee's regular rate of pay, and it's subject to a cap of $200 per day and no more than $10,000 total. And it's $10,000 because we're going out for a full 10 to 12 weeks here. And the reason it's capped at 2/3, if you go back to our original analysis under the emergency paid leave, it's capped at 2/3 versus the employee's full rate of pay, because this is leave that's designed to take care of someone else, i.e. your child that's out of school, as opposed to your own health condition. So if it were your own health condition, you would get 2 weeks of paid leave at your full rate of pay. Okay, so now you understand why this is not legal advice, because there's lots of details in all of this. Even with my giving you the general overview, there's so much more detail. And so if any of you, whether you be an employee or a business that's being impacted by this and or don't fully understand where you fit in the analysis, you definitely want to talk to an experienced attorney that can walk you through this and let you know exactly what your rights are as an employee or your obligations as an employer. Katie, are there any questions specifically related to this topic that you think would be good for us to take now? Or do you want me to finish the balance of the presentation and we'll circle back?
Yeah, there is one that I can ask that is connected right now to the FFCRA.
Okay.
We have one individual who asked, for the FFCRA, employers with less than 50 employees are exempt. Is that correct?
Yes, there are requirements to meet that exemption, but generally, if you're 50 employees or less, you would be exempt. Special considerations for that exemption, but the general answer would be yes, that if you have 50 or fewer employees, you should be exempt from these obligations, because it's intended to, it knows that this, my presumption is that Congress knew when it was passing this law that it knew it could have, present great burdens for smaller businesses. So for the most part, smaller businesses of 50 employees or less are exempt from this law.
Got it. Okay. And then one more final one that is directly connected before we move into the other questions is the FFCRA doesn't apply to government workers. Is there an act that applies to government workers, say local government workers, that you know of?
Right. It does not apply to government workers, and many laws, just even separate from this pandemic, don't fully extend to government workers, because government's given a lot of leeway and discretion to kind of determine its obligations to keep the government running. And so you will see with the city of LA and LA County and so many other jurisdictions that local government employees still are working, but provisions have been put in place for them to work remotely. And also that if they are experiencing symptoms of COVID-19 or have some type of diagnosis related to it, or have family members, that most governments are giving similar or same benefits, but they're not required to do so specifically under the FFCRA. But most government agencies, local government agencies in particular, are extending similar benefits to their employees.
Okay, got it. Thank you. So first of all, thank you so much, Angela, for your overview and kind of walking us.
Oh, wait, that's not it. I just have to go into the CARES Act for it quick.
Oh, yes. Yes.
Okay.
Sorry.
So the second part of the stimulus package, so to speak, is called the Coronavirus Aid, Relief, and Economic Security Act, which we also call the CARES Act. And I'll be much briefer on this. This was initially passed by Congress in the White House on March 27, 2020. And the goal of this is to help with the economic fallout of the pandemic. There's two phases. The first phase I've developed a nice acronym for it called SALT. It doesn't sound very good, so I welcome any marketing experts out there to give me a better acronym. But it essentially does four things. Two things for individuals or employees and two things for employers. For individuals, it expands the paid sick and family leave. So basically what I just talked about with FFCRA, what the CARES Act does is just solidifies that and emphasizes that those same benefits are still extended under the CARES Act. And then it provides expanded unemployment benefits for employees. And I definitely want to talk about that because most of the questions I get are related to unemployment benefits. And then for businesses, it provides a loan forgiveness program through the Paycheck Protection Act and also another portion called the EIDC. And it also provides tax relief for businesses. I'm not really going to talk about the L and the T for businesses because I really think you need to consult with your accountant or your tax person on those, because, and as I'm doing even as a business owner, because they're very specific in terms of what it takes to receive the forgiveness or to receive the tax relief. So I do feel that that's a little bit beyond my expertise, but I did want to identify it just so that you know fully in a simple way what the CARES Act provides. So the expanded paid sick and family leave, I just did a deep dive on that. That basically just emphasizes everything that's provided under the FFCRA. And then there's the expanded unemployment benefits. What's great about the expanded unemployment benefits, although individuals have been having trouble getting through to their state EDD agencies, is that it provides expanded benefits for employees that have been laid off terminated due to the COVID-19 pandemic. And it also provides benefits for independent contractors and individuals that work in the gig economy. So those individuals would not normally be eligible for unemployment benefits, but this act does extend those benefits even to those individuals. So just quickly, what does it take to be eligible? The employee or a member of their household has to be diagnosed with COVID-19. The employee has to be providing care to a family member diagnosed with COVID-19, or the employee is caring for a minor, a child that's unable to attend school. So very similar to the FFCRA requirements. Basically, either you have to be diagnosed or have an issue associated with COVID-19 or taking care of someone else. And your employment, your place of employment has to be closed or inaccessible due to COVID-19. These are all ORs, so any one of these eligibility requirements would qualify you for unemployment benefits. The employee becomes a head of household due to a COVID-19 death. So like say your spouse passes and now you're suddenly head of household, so you can qualify for unemployment, even if you're still working somewhere else. And the employee has to quit their job due to COVID-19. So many of the questions I've gotten are, my employer still requiring me to come to work. I'm an essential worker, but they're not providing me the equipment or the protective equipment that I need or a safe environment to continue coming to work. So I feel forced to quit my job. We call that under the law constructive termination. So, and generally, a person cannot qualify for unemployment benefits when they've been constructively terminated. But in this instance, the law says that if you feel that you have no other option but to quit because of the exposure and the lack of a sanitized environment or environment that respects social distancing or that provides the proper equipment, then you possibly could qualify for unemployment benefits. The other great thing about this expanded law is remove the number of the barriers that we would normally see in applying for unemployment benefits. So for one, employees are not required to have worked a certain amount of time to qualify. So literally, if you started work today and tomorrow, you meet one of those 6 eligibility requirements or one of those eligibility requirements that I just listed, then you could possibly qualify for unemployment benefits. So you don't have a normal waiting period. In California, the normal waiting period is at least a week or more, I believe. And then, as I indicated, self-employed individuals can qualify for unemployment benefits, and employees are no longer required to wait after a layoff or separation to receive unemployment benefits. They can apply immediately upon being out of work. So you don't have to wait to get formal letters or to go through a formal process. You can immediately qualify. And individuals that have had their hours reduced. So you still may be working, but you went from 40 hours to 30 hours or 40 hours to 20 hours a week. You can apply for unemployment benefits for the portion of your wages that have been reduced. We've heard in the news this week that many employees are making more money on unemployment than they would in their regular jobs. So employers are a little concerned about whether people will want to come back to work, or at least come back to work before their unemployment benefits run out. And then one of the requirements generally for unemployment is that you are actively seeking work. In this instance, yes, there's an expectation that to the extent you can, that you are actively seeking work, but the requirement is not as extensive that you show that every day you went online or went somewhere to find a job. Those requirements have been relaxed. What are the benefits? Again, there's lots of detail here, but the highlights of the benefits are an additional $600 a week in unemployment pay on top of whatever you may receive through the state benefit. The benefits are retroactive back to January 27th of this year. So if you were out of work as of January 27 and you're still waiting for or still attempting to apply for unemployment benefits, once you finally get through, you should date your application back to the date that you were unemployed, at least, if that date was as of January 27th. The benefits can be claimed up to 39 weeks total. So many individuals will, have asked, I've run out of my benefits, can I get additional benefits? So if you haven't maxed out at 39 weeks, which you would not have by this time, then you can seek benefits up to 39 weeks. And I've already indicated if you've been furloughed or had your hours reduced, you could qualify as well. And that extension of that total of 39 weeks also applies to self-employed individuals and independent contractors. And then, as I mentioned, I'm not going to talk about the loan forgiveness programs or tax relief programs for employers, but generally those are opportunities for employees to seek added funds to help cover overhead expenses, or to seek tax relief or relief in terms of paying payroll taxes, which can be quite substantial for employers during this pandemic. Hopefully, I believe you already have had accountants, financial experts, etc., that can speak to those two areas. So I will stop there so we have used the balance of the time for questions.
Perfect. Thank you so much, Angela, for that overview. Now we are going to get into questions and Q&A time with you. So I'm going to start with some of the questions that were submitted when individuals registered for this webinar. So we'll start with a few there, and then we'll take some more that are coming from the live Q&A. So my first question is, what are some common legal risks with having a remote work policy or practice? And do you have any recommendations for managing remote employees effectively?
Okay, some of the common legal risks are that employers feel that because you're working remotely that the rules are somewhat laxed, and they're not. So you still want to make sure that as you are setting up employees to work from home, that you encourage employees to be in a safe environment and to confirm that they're working in a safe environment, to be sure to provide the employees with all of the equipment and the materials that they need to effectively do their job. And the law actually requires employers to ensure that they cover expenses like internet and phone or anything that's required for that employee to do their job. You're not required to pay their rent or their mortgage because they will be required to do that as well. And not necessarily even their utilities, although many employees will experience higher utility bills. So I encourage employers to consider some type of payment for a portion or prorated portion of the employees' utility bills. And then you want to have a system in place where you're able to check in with the employees, make sure that they don't feel that they're experiencing any forms of discrimination or harassment, or that they feel safe in their work environment. You also want to make sure you have a system for managing employee time, particularly non-exempt employees, that they are taking their required rest breaks and meal breaks every day. So the same laws that apply when an employee is at work apply when an employee is not at work. And they're actually more challenging because there's no one there to provide oversight. So you really want to create a system where someone is able to check in and to be available and to help employees navigate during this time frame.
Wonderful, thank you. My next question is, can you discuss employer responsibilities when keeping offices open during COVID-19 or during COVID-19 restrictions, and any guidance on considerations when it comes to reopening offices?
So first, under local ordinances, right? Well, if you're in California, under the state ordinance, as well as most local ordinances, and I believe this is the same in many states, not all 50 states. We've all been watching the news that some states are getting back to normal, but if you are in a state or a locality that still states that only essential businesses that provide essential services or have essential employees should be open right now, you should not be open. So that's the first thing. Only if you're an essential business should you be open. If you are an essential business open, then you want to continue to observe the normal employment laws. There's nothing in any of the expanded laws that reduces any of the requirements to have an environment that's free of discrimination, harassment, to provide meal and rest breaks, etc. All of those things that we require. But above and beyond that, you want to make sure you have a safe environment, extra sanitizing. I know that there are janitorial and cleaning companies now that are getting special certifications to clean environments during this time. So you want to be contracted with companies like that if you're not already. You want to make sure that you have social distancing. So one of the things that restaurants are thinking about when they come back is having fewer tables or not allowing folks to sit close to each other, even if they have the same amount of tables. So whatever your work environment is, you want to make sure that the workstations accommodate social distancing, and that you allow employees to wear masks, and that you allow employees to do the things that they need to do to feel safe and comfortable in the work environment, and really just limiting the possibility of an employee being exposed to COVID-19 or feeling unsafe in their work environment.
Thank you. Those are some really good considerations and tips. My third question is, how can someone as an individual encourage accountability in leadership and better advocate for themselves during this uncertain time?
Yes, so I think this is probably coming from an employee.
Mm-hmm. Yes.
Like. So many companies are doing a great job, and they're being very clear. They have messages coming out from the leadership, written messages, video messages. They clearly made it who's in charge, who to talk to, if this is happening or that's happening. So if you're in an environment where that's not happening, I always encourage folks to start with their human resources department or human resources leader, or even your manager or supervisor, to say, hey, I am not feeling as supported as I need to feel during this time. And I imagine if it's me, that other employees are having the same reaction and feeling the same way. So is there anything that our company or organization can do, one, to increase communication, two, to make people feel more connected, and three, just so we know who's accountable and who is responsible during this time frame. So I would start a conversation, with your manager, with your supervisor, with the powers that be, and start it in a non-adversarial way to give them an opportunity to be responsive and to try to do the right thing and to try to create culture even in this socially distanced and remote working environment. That's a really hard thing, to create culture, to maintain culture. Many companies, many managers are hosting Zoom meetings with their teams and using those meetings to do check-ins and to do fun things so that people still feel connected. And many managers are reaching out to their team members one-on-one. So I encourage that. And if you don't feel you're getting that, raise the yellow flag, not the red flag, raise the yellow flag, so you give your company or organization an opportunity to step up to the plate.
Wonderful. Great insight and advice. My fourth question is, what protection does a person with a pre-existing condition have when requested to return to the workplace?
Right. Well, you have the same protections, even not in a pandemic situation. But the question is whether your pre-existing condition is associated with COVID-19. If it's associated with COVID-19, that will determine if you qualify for any of the expanded leave protections that we talked about in this call, or if it's evaluated just under the normal leave protections, such as the Family Medical Leave Act, or in California, we have extended sick leave laws and requirements, and other extended sick leave laws that above and beyond what we have in the Family Medical Leave Act. So first, it would be getting a clear diagnosis from your doctor, so that when you go to your employer and say, I need additional time off, your employer knows how to qualify that or how to designate that, whether to designate it as a COVID-related leave or some other type of leave, and that'll help them determine, what leave to assign you to or to designate for you.
Great. So my final question before we continue to take more questions through the live Q&A is, how do you recommend leaders balance what's best for the longevity of the organization?
That's a really tough question. And the thing I've been most humbled and excited to see during this time is that most employers and leaders are trying to do the right thing. They're trying to keep their businesses and organizations going as much as possible, where they can, while also being, really scared about the future for their business. Simultaneously working with their accountants and their financial advisors to get these paycheck protection loan applications on file and other, tax relief and paid protection applications on file, which takes a lot of time. So I would say, stay abreast of the law, be in close contact with your lawyers, your accountants, your financial advisors, and others to understand what's going on and how it's impacting you, so that you can make daily decisions and project out as much as possible about what the future looks like for your business, while also putting plans into place that help your employees know exactly what's happening. Be transparent with your employees. I mean, they don't have to know all the details. Today we applied for this or today we did that, but let them know you're actively working to keep the business going and that you appreciate their efforts, you appreciate what they're doing to continue doing their jobs, and as much as possible, you're going to try to protect them and keep folks working. As I stated in an earlier question, make sure your managers are equipped to speak to employees and to check in with employees, encourage that. I think that the biggest thing we can all do during this time is keep the lines of communication open and to be transparent.
Yeah, absolutely. I echo that for sure. So now we'll take some of the questions that have come in during this live webinar. So my first question of those is, can an employee claim exposure or case of COVID as a work-related workers' compensation claim?
It's possible. So certainly for those individuals who are still working at a physical site, I think you can claim that it's work-related, even though you're required to work from home. But the argument from the employer would be, well, you could have gotten it from a family member or someone visiting the home or what have you. But certainly if you're going to work every day and you can draw a clear connection that there's no other way you could have contracted the virus other than through work, then it's certainly possible to make a claim under workers' compensation laws.
Got it, sorry. So my next question is, since kids cannot go to camp during summer due to COVID, will that count as school out?
That's a great question. I don't think we know the answer to that because it definitely covers traditional school and school time. But I do know that many parents, as a part of school, send their kids to after school camp or summer camp. It may extend to cover that situation as well. It can be argued because most parents rely on some form of daycare, summer camp, other care,
Right.
to help with their children while
definitely.
they're working.
So are there pros and cons for independent contractors applying for regular unemployment benefits in California versus the pandemic unemployment benefits that opened yesterday?
I don't think you're prevented from applying for both, actually. I know contractors that are applying for unemployment benefits plus the loan forgiveness. The problem is all of this is moving at the speed of light, and many of the agencies, even Congress, as they're thinking through this, they're not having a chance to line up all the dots. So will it later, bite you in the butt, so to speak? That remains to be seen. But right now, there's nothing that prevents you from applying for both, and particularly because the unemployment offices, as well as depending on where you are in line with your bank and pursuing some of the added relief, it may be a matter of which one comes through first for you.
Yeah, absolutely. And that's great that people can apply to both and hopefully, get good things come from that.
Yeah, but that's one of those questions I definitely say talk to your accountant about, because they probably have, they for sure have better advice and counsel as the impact on how you have to claim it on your taxes and what it looks like in terms of forgiveness or non-forgiveness, or, does one set off the other?
Right.
Set off to the other.
So my next question is, I had from Lisa, I had read that essential workplaces have to provide hand sanitizer to anyone entering, as well as requiring masks and social distancing. Does that mean businesses have to provide masks or not let persons enter if they aren't wearing masks?
For their employees, I would strongly encourage the businesses to provide the mask. I've gotten lots of calls, and even calls from hospitals, individuals that work at hospitals saying, I have to have a mask, and they are, there's not enough masks to go around. Aren't there requirements for the hospital to provide us masks, clean masks every day? And yes, because of doing your job. And but I think the reality of it is, up till recently, it's been very difficult to get masks, especially the kind that the ultimate protection, as opposed to the mask that if you work in an environment where you're required to have a mask, the employer should be providing that.
Great. So if you are told you cannot work remotely and take Fcra or FMLA, that is a total leave, correct? Like you cannot be asked to work, but could an employer alternately choose to allow you to work all or part-time from home?
I'm not questioning. There are very specific eligibility requirements for FFCRA, and for the expanded family medical leave benefits. So if you qualify for one of those and your employer is 500 or fewer employees, or let's say between 51 and 500 employees, because employers are 50 or less have an exemption, then your employer most likely is obligated to provide that expanded leave and not allowed to require you to in exchange for the leave. Then they may require you to work remotely. If they're an essential business, they may require you to come into work. So you really have to kind of zone in on what exactly your situation is and what you qualify for, and that will determine what the employer's obligations are.
Got it. Are firms with more than 500 employees required to do anything?
Yes. I mean, they have a heightened duty to provide leave and to provide, you know, the individuals are coming to work to provide protective equipment, etc. And the same duty to apply with the normal laws that are on the book for family medical leave and other expanded leave and sick days. So it's not limited to just the 500 or fewer employees.
Got it. Is there any assistance for employees affected by pay cuts but still working the same amount of hours?
Affected by pay cuts. So the basic law says employers have to pay employees for all the time that they work. So if an employer is reducing pay, then hours should be reduced in accordance with that reduction in pay. We know that in this environment that many employees, even on their own, are wanting to go above and beyond for the employers and saying, hey, I'll work even if you can't pay me, or even if you can't pay me my full pay. But if we look at it from a strict legal analysis, employees are entitled to be paid for all of the time that they work. So I would discourage a practice where an employer reduces pay and doesn't, you know, simultaneously reduce hours associated with that pay.
Got it. So this is probably our, I think, second to last question because we want to leave some time to wrap up. So when workplaces begin to open up again, can employers prevent certain employees from returning to work if they are deemed at risk, including those who are over 60 years old?
Wow, that is definitely a question you want legal advice on because it could create a landmine of a situation.
Sure.
So I would start by saying, you know, employers, as they do in normal hiring situations or return to work situations, have to make sure that they are treating everyone fairly and equitably, and that they're not discriminating against individuals based on medical condition or any other issue associated with race, gender, ethnicity, religion, disability, all of those things that we can't treat people differently. If you believe that someone has the virus or is asymptomatic or what have you, you can require that, and I would say you require this across the board though, that individuals provide a certification from their doctor that they are free of the virus. And the rationale behind that is that you're wanting to make sure that you create a safe work environment. But I would not advise singling out any one employee unless you have reason to know based on that employee telling you, or it was, you know, known throughout the pandemic that this employee possibly had the virus, then you may just want to focus on that employee. But you don't want to make assumptions about any one employee, and the best approach would be to treat everyone the same, to say, hey, we're going to return everyone to work, but before we do need some kind of certification from your doctor that you're healthy and it's safe for you to return to work. Treating people differently because of their age, although individuals who are 60 and over have been placed in a category of being, you know, having to be more careful than others because of their age, I would discourage a practice of not bringing back people who are 60 or over because of that susceptibility. The greater obligation is on the employer to create a safe environment that that person feels comfortable coming back to, and to, if you feel this, like I said, if you feel someone has the virus or, you know, more susceptible to it, then you may want the doctor's note across the board that certifies that the person is able to return to work.
Great, that's super helpful. So my final question is, do the FFCRA and CARES Acts have a sunset provision? How long do they remain in effect?
FFCRA is in effect through the end of this year, And the CARES Act, the unemployment benefits part of it, is currently through July, but it's actually longer than that because you can have up to 39 weeks of leave. So most likely it would, if you qualify for the max of that, it would go through December of this year, depending on when you started your unemployment benefits.
Got it. Wonderful. All right. Well, that's all the time we have for Q&A today as we wrap up our webinar. So I want to say thank you so much, Angela, for taking time and to join us today and share your knowledge and expertise with Bruins who are managing new expectations as employees, managers, and employers during this time. We're so grateful to have alumni like you. After this webinar, you can find and connect with Angela on UCLA One, as she is one of our most active users on there. Are there any other ways, Angela, that you'd like Bruins to connect with you on social media?
You send me messages on my LinkedIn page, which is Angela Reddock-Wright.
Perfect. Fantastic. So UCLA One LinkedIn, you can find her there. As a reminder, today's webinar is recorded. We'll be sharing the recording as well as Angela's slides that she prepared and any of the resources referenced in a follow-up email to you all sent out within a week of today. And I want to remind you all that we are in this together. If you want to connect with other Bruins, we encourage you to sign up for a profile in UCLA One to get started today. You can promote your business and services, post and find jobs, and network with like-minded people and industry colleagues. So the UCLA network is a powerful one, so don't hesitate to take advantage of it today. And on behalf of us here, thank you for your time, and go Bruins.
Thank you so much. Go Bruins.